Karen Reed finally filed her lawsuit. Well, actually, she filed her lawsuit on the 17th, and today is the 28th. So I'm a little late getting to this, but I'm here now, okay? I'm here now. Anyways, Karen Reed filed a banger of a lawsuit. The complaint was such a masterpiece. I wish that I could put it in my Goodreads. I would rate it 5 stars just for the world building alone, okay? Karen Reed is suing Michael Proctor, Yuriy Bukhenik, Brian Tully, Brian Albert, Nicole Albert, Jennifer McCabe, Matt McCabe, Brian Higgins, and she also plans to include Mass State Police and the town of Canton in her lawsuit, but there's some procedural things that she has to do before she can add those entities into the suit, but it's coming. And this is actually a separate action from the Okeefe suit that they filed against Karen Reed. This is in Bristol County and the Okeefe suit is in Plymouth. They do plan to move to consolidate these two, but that has not happened yet. So as of now, these are 2 separate actions. This complaint says everything that Karen Reed, Alan Jackson, David Yannetti, and Robert Alessi were not saying in all of the interviews that they've done. Everything that we've been wondering, the questions that they were asked and they tiptoed around the answers, not happening here, okay? Those questions are answered. We get their theory of the case. We get to know exactly what they think happened in that house in January 2022. So they tell us that in the early morning of January 29th, 2022, Mr. Okeefe was killed in Brian and Nicole Albert's home at 34 Fairview Road in Canton in an altercation during a late night house party with other defendants, collectively known as the house defendants. That includes Brian, Nicole, Jen, Matt, and other Brian, okay? And yes, we will be calling them the house defendants going forward. This complaint lays out every way that Proctor and his homeboys screwed up this investigation. Proctor and his friends shielded the house defendants by intentionally sidestepping fundamental investigative procedures. Proctor did not search the house despite Mr. Okeefe's missing pieces of clothing that he should have been wearing, i.e. his winter coat. It was a blizzard, they said, okay? Missing a coat. Didn't go in the house to try to find it. Missing a shoe. Didn't go in the house to try to find it. The house was never processed by a criminalist or even photographed. No member of Mass State Police stepped foot inside of 34 Fairview for nearly a week. No member of Mass State Police conducted physical examinations of the house defendants to look for evidence of involvement in an altercation. They did not seize the house defendants' phones. They conducted only perfunctory, unrecorded conversations with Proctor's friends, and they made no attempts to corroborate their stories. They just took all of those weirdos at their word. They permitted would-be witnesses to coordinate the stories before any formal interviews, and they allowed critical evidence to be manipulated and destroyed. So basically what they're telling us is there was no police work being done, okay? None whatsoever. And every time I hear about all of the things Mass State Police did not do as part of their investigation into the death of John Okeefe, I wish more and more that Judge Cannoni would have let Michael Easter, the retired FBI agent, testify on Karen Reed's behalf, because I saw an interview that he did with the lawyer you know, and he really just gave an amazing breakdown of all of the steps that they should have taken as part of their investigation, and they just didn't do it. And even though we all know the investigation was trash, the jury figured out the investigation was trash, I would have loved to hear him paint the picture for them on the witness stand. So after explaining all the things Proctor didn't do as part of his investigation, they go on to tell us what he did do. And they left no room for confusion here, okay? They let us know Proctor went as far as to manufacture evidence to ensure that Miss Reed was blamed and not his friends or fellow officers. This included planting evidence at the scene on Mr. Okeefe's clothes and Miss Reed's car to support the false narrative that Miss Reed hit Mr. Okeefe with her car, even though he knew Mr. Okeefe's injuries were inconsistent with the vehicle strike and consistent with a dog attack. And contrary to what every Mass State Police witness on the stand said, this investigation was not objective and it was done without honor or integrity. Proctor sexualized and dehumanized Miss Reed throughout the investigation. In private communications with his high school buddies, he called her multiple derogatory names, which I'm not going to repeat here. Everyone knows what they are. He ridicules her for her medical conditions, and in private messages to his Mass State Police supervisors and colleagues, he bragged about looking for nudes. No nudes so far. His immediate supervisor, Yuriy Bukhenik, sent a thumbs up to a text message of Proctor calling Miss Reed the R word, and Proctor supervisors knew of his close relationship to the Alberts, and he made no secret of his bias, demonstrating clear prejudice from the outset. Relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing to the House defendants, the Commonwealth secured 2 separate arrest warrants for Miss Reed and prosecuted her for murder twice. These acts violated Miss Reed's state and federal constitutional rights. Miss Reed was acquitted of all charges related to John Okeefe's death. Proctor was fired, and nearly all officers in Proctor's chain of command were disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the Okeefe family, not to the community, and certainly not to Miss Reed. Miss Reed's life was forever changed by the defendant's misconduct, transgressions, and wrongdoings. Mr. Okeefe's killer or killers still walk free. And that was just the intro. Karen Reed's civil complaint was written in the plainest English you could imagine. I'm pretty sure Yuriy Bukhenik was able to read this and understand what she was saying without using a thesaurus. And when it comes to civil cases, judges are supposed to read these complaints and take everything the plaintiff says as true. So the way she lays out the facts of this case is going to be very difficult for any of these defendants to get a dismissal, because she told us exactly who was involved in this frame job, conspiracy, cover-up, whatever you want to call it. She let us know who was involved and exactly what she thinks they did. John Okeefe was involved in a physical altercation inside the house or garage, and during that altercation, he was attacked by Chloe, aka Cora, the Albert's German Shepherd, suffered an incapacitating contractile wound on the back of his head from falling backwards and hitting his head on a ridged surface. The head wound could not have been caused by a vehicle strike or by falling backwards onto a flat, cold lawn like the Alberts. Because of their knowledge of criminal investigations, the House defendants knew that calling for medical care to help save Mr. Okeefe would trigger immediate and irreversible risk of their own criminal exposure. Therefore, the 5 of them agreed on a plan to exonerate themselves and implicate Miss Reed. They would tell anyone who inquired that Mr. Okeefe never entered the house, and they hid all evidence that he was there, including his body. Sometime during the night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view of that area of the lawn. At some point later in the night, they carried or dragged Mr. Okeefe's body to that same area of the lawn, and they devised a plan that would make it appear that Mr. Okeefe was struck by Miss Reed's vehicle and then died in the snow. After the altercation, Higgins drove to Canton PD in the middle of the night, where he claimed to be doing administrative work. Later, video showed Higgins walking down the hallway and entering offices wearing a hoodie to obscure his face, and he was later shown transporting a large bag from one vehicle to another before driving away. Higgins and Albert called each other multiple times and spoke on their cell phones at 2:22 a.m. Both Higgins and Albert denied the existence of these calls, and when confronted with their existence by a separate law enforcement agency, aka the FBI, they claimed that they were all butt dials. 5 minutes after the call, Jen McCabe performed a Google search on her phone at 2:27 a.m., the infamous Haslang to Diane cold. Miss Reed began searching for John Okeefe on January 29th, just before 5 a.m. She called Jen McCabe, who insisted that Miss Reed drive to her home instead of 34 Fairview, which Miss Reed did. They were joined by Carrie Roberts, and the 3 of them left to go back to Mr. Okeefe's home. The illogical McCabe-directed route allowed the House defendants more time to finish creating the scene and hiding evidence before Mr. Okeefe was discovered and first responders arrived. As the House defendants planned, Mr. Okeefe's body was discovered on the front lawn of the Alberts house, and the Ford Edge that had been parked in a position to obscure Mr. Okeefe's body had been moved. While Miss Reed and Miss Roberts administered CPR, McCabe did nothing. She sat in the car, she called 911 to report a man passed out in the snow. She never went in the house, and it's just so crazy to me. There was a man passed out, lying, seemingly dead, in the snow, on her sister's lawn, and she never went inside the house to check on her sister. That is wild. There would have been nothing that could keep me from getting to my sister to make sure she was okay if that was the scene I witnessed. Absolutely not. No. And add in the fact that her brother-in-law was a first responder and she never went in the house to get him to help. I'll never understand that. Canton PD was on the scene shortly after 6 a.m. At that time, there was no evidence that John Okeefe had been struck by a vehicle. His body did not show signs of trauma commonly associated with being struck by a car. Mr. Okeefe's injuries were consistent with being physically assaulted to the face and head and attacked by a dog. The ranking Canton PD officer on scene, Sergeant Michael Lank, opined that Mr. Okeefe looked like he had been in a fight. That was caught on dash cam, I believe. The initial search conducted by Canton PD revealed no vehicle debris in the lawn at 34 Fairview, let alone near Mr. Okeefe's body. Not a single piece of taillight material was found on the lawn or in the roadway, notwithstanding multiple searches and use of a leaf blower to remove snow. Despite the commotion outside, no one from the Alberts' house, including the police officer, the trained first responder, Brian Albert, ever came outside to see what was happening or help. Lank was a longtime friend of the Alberts and the first law enforcement officer to enter the house. He and the Alberts and the McCabes, they spoke, and of course, they told him John Okeefe never entered the home. Neither Sergeant Lank or any other Canton PD officer searched the house to determine if the occupants or anyone else was involved in Mr. Okeefe's death, nor did they request to search the cell phones or observe their bodies for any evidence of a fight. 2 hours after being interviewed at the Albert home, Jen McCabe called Sergeant Lank to report that she recalled additional information. She falsely told Lank that Miss Reed told her twice, "I hope I didn't hit him." Proctor was assigned as the case officer. Bukhenik was Proctor's direct supervisor, and Tully was the supervisory officer at the Norfolk County State Police Detective Unit. Tully and Bukhenik knew at all times the extent of Proctor's misconduct. Proctor never should have been assigned as the investigator. He is good friends with the Alberts and had a personal cell phone number for Julie Albert, Brian Albert's sister-in-law. And he had communicated with her just days before John Okeefe's death about Julie maybe babysitting his child. The existence of these relationships was intentionally suppressed by Proctor and members of the Mass State Police in an effort to ensure that the House defendants were protected. Proctor, Bukhenik, and Tully never searched the house for DNA or ridge surfaces that could have caused the gash on Mr. Okeefe's head. They never inspected the house defendants for bruises or cuts that could have resulted from a physical altercation. They didn't search their phones. The house defendants' interviews were conducted outside of normal protocols in places like their homes, family members' homes, their lawyers' homes, or their lawyer's office, and the interviews were not recorded. And that's why so many of the Commonwealth's witnesses were able to get on the stand and deny saying things that were included in Proctor's reports because they didn't record it. Mass State Police failed to conduct a meaningful investigation into Brian Higgins, even after he presented them with hand-selected text message printouts revealing his flirtatious text with Karen Reed, and video surveillance showed Brian Higgins at Canton PD at 1:30 a.m. on January 29th. They still didn't interview him. They still didn't investigate him. And they also hid that CPD footage until well after the first trial. Mass State Police chose not to collect evidence from Brian Higgins or Brian Albert's cell phones, even after learning that they had destroyed their devices within days of each other, eliminating possibly incriminating communications. Even after learning that Karen Reed had entered a preservation request, we all know Brian Higgins took his phone and destroyed it at a military base. He threw the phone in one dumpster, cut up his SIM card, and threw that in another dumpster. That's a problem. They didn't look into it. Proctor shared investigatory details with his sister Courtney before they were public, and Mass State Police just accepted false coordinated statements from the House defendants, and they didn't make any efforts to corroborate their stories. They literally just took these people at their word in a murder investigation. Like, it doesn't make any sense. Rather investigate their friends and brethren, they targeted Karen Reed. So Karen Reed is suing a lot of people for a lot of things, right? Michael Proctor, Yuriy Bukhenik, and Brian Tully are all being sued in their personal capacity, not as Mass State Police troopers, not in their job. They're being sued as individuals. And as far as the counts go, count one, malicious prosecution under the Fourth Amendment against Proctor, Bukhenik, and Tully, and Karen Read does intend to add Mass State Police to this particular count. She's saying that Proctor, Bukhenik, and Tully violated her Fourth Amendment rights by engaging in malicious prosecution of Ms. Read by causing her to be seized pursuant to legal process unsupported by probable cause. Count 2 is supervisor liability. This is against Bukhenik and Tully in their individual capacity. A supervisor is liable when the supervisor supervises, trains, or hires subordinates with deliberate indifference toward the possibility that the subordinate's deficient performance will result in the deprivation of an individual constitutional right. And she's saying that Brian Tully and Yuriy Bukhenik should have known that there was a grave risk that Proctor would fail to investigate the Alberts, with whom he had a close personal relationship with, because he had disclosed it to them. Not only that, but when Yuriy Bukhenik was disciplined after the first trial, it was because of his failure to supervise. Count 3 is conspiracy to deprive Ms. Read of her Fourth Amendment rights. This is against Proctor, Bukhenik, Tully, the Alberts, the McCabes, and Higgins. She says Proctor, Bukhenik, Tully, the Alberts, McCabes, and Higgins shared a common design and acted in concert to frame Ms. Read for Mr. Okeefe's death. As part of their concerted efforts and among their many misrepresentations, the Alberts, McCabes, and Higgins agreed with each other to tell investigators that Mr. Okeefe never entered the house, they did not see Mr. Okeefe in the house that night, and that Ms. Read made inculpatory statements on the morning of January 29th. That's the I hit him, I hit him, I hit him. And she says that when they made those statements, the House defendants did so only because they were aware that Proctor, Bukhenik, and Tully would also act similarly by solely investigating Ms. Read, which they proved by only solely investigating Ms. Read and by literally taking their statements like as gospel. Count 4 is Massachusetts Civil Rights Act, MCRA. This is against all of the defendants, Proctor, Bukhenik, Tully, the Alberts, the McCabes, and Higgins. Proctor, Bukhenik, and Tully, as well as the House defendants, interfered or attempted to interfere in Ms. Read's exercise or enjoyment of her rights under the federal and Commonwealth constitutions and laws through threats, intimidation, and coercion, among other acts, by manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins' phones, and ignoring exculpatory evidence such as the dog bite injuries, the lack of injuries consistent with a vehicle strike. Proctor and Bukhenik caused Ms. Read's wrongful indictment, arrest, and prosecution, thereby interfered and attempted to interfere with her rights under the Fourth Amendment to the United States Constitution and Article 14 of the Massachusetts Declaration of Rights. Count 5 is the common law malicious prosecution. This is against all of the defendants again, and they include the same acts here: planting evidence, not searching the phones, not securing the scene, all of those things. Those acts are also included when it comes to count 6, which is intentional infliction of emotional distress. This again goes against all of the defendants. Count 7 is civil conspiracy. This one again goes against all of the defendants. Proctor, Bukhenik, Tully, Alberts, McCabes, and Higgins says that as part of their concerted efforts and among their many other misrepresentations, the Alberts, McCabes, and Higgins agreed with each other to tell investigators that Mr. Okeefe never entered the house, that they did not see Mr. Okeefe in the house that night, and that Ms. Read made inculpatory statements the morning of January 29th. And when they made these statements, the House defendants did so only because they were aware that Proctor, Bukhenik, and Tully would also act similarly by solely investigating Ms. Read, which we know that's what they did. Proctor, Bukhenik, and Tully knew or should have known the statements made to them by the House defendants were false, and that obvious and easily obtainable evidence existed demonstrating Mr. Okeefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head open, and was attacked by a dog. Instead, because of their close personal relationship to the other House defendants, they agreed with each other to use the House defendants' misrepresentations as the predicate for an implicit direction to conduct an investigation that solely targeted Ms. Read to the exclusion of everyone and anyone else. And there you have it. That's what they did. So obviously, Karen Reed is demanding a jury trial. Duh. And prayers for relief. The only option here is money. It's a civil case. She can't arrest them and have them tried for a crime because that's not her job, but she can ask them for money. And the amount of money that she should get should bankrupt them. That's what she deserves. And obviously, this complaint is respectfully submitted, Karen Reed, by her attorneys, okay? XOXO Alan Jackson.